Hours of grand jury proceedings in the Breonna Taylor case are now available to the public. It is rare to release such material. You will recall last week a grand jury brought no criminal charges against 3 Louisville police officers for Taylor's killing. This angered many in that city and around the country. Kentucky Attorney General Daniel Cameron's office led the investigation into Taylor's death. He did not object to the grand jury proceedings being made public. He did, however, ask for an extension to edit out personal information from the material. This is, of course, a developing story. We have more than 20 hours of material to comb through, and as soon as we learn anything relevant, we'll let you all know. But for now, I want to bring in Rebecca Roiphe. She's a CBS News legal contributor. Rebecca, thank you so much for being with us. So first off, why is it unprecedented for grand jury recordings and transcripts to be released? I don't know if it's unprecedented. I'm sure it's happened before, but rare. Why is this so significant?
Right. It's extremely rare because grand jury proceedings are normally secret, and that is in order to protect the idea of grand jury secrecy is to protect a person who is accused but not yet charged of a crime. And so there are really important reasons why you would want to have all of the deliberations be secret. But of course, in a public case like this, the prosecutor can decide that it's in the best interest, and the court can decide that it's in the best interest of the public to make these proceedings public. So while it is incredibly rare and very unusual, in these police shooting cases, it's not unprecedented. Like the grand jury minutes in the case in Ferguson were also released. And so, you know, it's unusual, and it gives us a glimpse into a process that is usually opaque.
And of course, there are hours and hours of material here to comb through. What are lawyers for Breonna Taylor looking for most carefully? Is there something specific that they want to pinpoint?
A couple of things. So one thing is that Attorney General Cameron said that he presented all the evidence to the grand jury, and the grand jury agreed that the appropriate charge was that one charge against the officer who did not shoot and kill Breonna Taylor, but rather shot into the neighboring apartment. And so we're looking for the evidence regarding that. So was he accurate and truthful when he said that he presented all the evidence to the grand jury? And second, what charges? So he says that he recommended, he has now told the public that he only recommended that one charge. But he also said the grand jury had sufficient evidence that if it had wanted to on its own, it could have brought the murder charges against the 2 other officers now, or manslaughter charges against the 2 other officers. So everybody's looking for those recommendations. What exactly did the prosecutor do? How did he lead the grand jury? And I just want to make one thing really clear, which is a prosecutor's role in the grand jury is very different from his role with regard to the regular jury, because a regular jury hears evidence from both sides. But in a grand jury, it is typical that a prosecutor will lead a grand jury where it wants to go, where the prosecutor wants the grand jury to go. The prosecutor makes the decision, first off, whether charges are even warranted. So there's nothing wrong with him actually leading the grand jury to where he wanted to go, but there's certainly something wrong with him hiding behind a grand jury, taking the legitimacy of this grand jury and acting as if it was the grand jury's decision if it was his.
And Rebecca, correct me if I'm wrong, but that's the whole reason we're here, right? There's a juror that kind of came forward and said, look, I feel like the Attorney General is leaning on us. You know, that's why we want this all to be public.
Exactly. And, you know, it's a complicated process, and it's not all that clear, but I think that's what we're all looking for. So how open was he with the jury? How much involvement was the jury allowed to have, and how did he direct them? How much did he push them? And was he accurate when he made that explanation when he came public? Because there really isn't anything wrong with a prosecutor going in, and he doesn't even have to go to a grand jury to start with. So he could have just decided on his own that it wasn't appropriate to charge either of these 2 officers, and that would have been fine. Again, what's wrong is if he goes into the grand jury in an attempt to have a partner, have a kind of public community partner in this decision, and in fact, it wasn't a partner at all. And so that is, in essence, the allegation of this grand juror. So everybody what we're looking for is how fair and open was he? How much evidence did he he put? How slanted was that evidence? And did the grand jury really get a chance to look at these facts and determine whether, under the law, they amounted to sufficient evidence to prove a murder or manslaughter charge?
And so, Rebecca, at the end of the day, what can come of all of this? I mean, the decision has been made at this point. Is there a chance that additional charges could be brought?
I mean, if first of all, there's also a parallel investigation going on by the FBI. So, there could be federal charges, federal civil rights charges in this case, and that investigation is ongoing. And I really think that investigation is, in some ways, the more important one, because that has to do with that's this question of how they got this warrant and did they lie to the warrant. None of that was considered by this attorney general. That's all going to be taken federally, and I wonder about that process and whether there weren't some irregularities, if not, outright, fraudulent conduct in that regard. But, that's an entirely separate matter. So then the question is with regard to state charges, could there be another grand jury convened? And the answer to that is yes. Cameron himself was a special prosecutor, but if through this process it looks like the process was corrupted somehow, or the attorney general himself lied or something like that, it is possible that you could have a new special prosecutor appointed to conduct a new investigation, or at least present the evidence to a new grand jury. But, again, we have these protections in place for defendants. The grand jury's decision to not to charge them is significant, and it is, it means something, and so unless the attorney general is really misrepresenting the evidence, then I don't think there would be any further proceedings.
All right. Well, Rebecca Roiphe, thank you so much for joining us.